We filed a motion to sever and abate. I think it was like October, November. We would just like to sever and abate the extra contractual claims from the deck action. And if there's any other non-extra contractual claims, we'd like to sever and abate the extra contractual claims from that. I've cited a litany of cases that stand for the proposition that it's my understanding that the sever and abatement should always be granted if there is a deck action or breach of contract pled, which there is in this case. They filed a response highlighting that November 19th case out of Fort Worth Court of Appeals, which is kind of out there, that tries to resurrect the Arnold decision. But if you read that case closely, it actually does reinforce the fact that case had to deal with whether this extra contractual discovery could be done after there was a judgment that State Farm had paid. That's not what we have here. What we have here right now is we're seeking severance and abatement, which even that case said that, Judge Birdwell was using the litany of cases that says you can sever and abate the extra contractual claims as partial reasoning for the fact that that type of discovery may be contemplated down the road after you get that initial judgment. And I'm not asking the court to rule on whether they can do that discovery down the road. I'm just asking for it severed and abated pending the outcome of the declaratory judgment action in this case.
Did you have anything else, Mr. Stillwell?
I think that covers it all on the motion to sever and abate. Jackie, Ms. Chandler, can you think of anything else?
If I can unmute. No, I think that covers it. I think that case is distinguishable. The Fort Worth case.
I'm sorry, I didn't mean to interrupt you, Ms. Chandler. Did you have anything else?
No, Your Honor.
Ms. Jobin, did you have a response?
Yes, Your Honor. I've actually argued this prior to Justice Mulberg leaving the 95th District Court on these issues in the past. It's my understanding that Mr. Lohr has the same intention that I did previously, and it was also with Allstate. And so I understand these arguments, and I understand the arguments Mr. Stillwell is making. And I think where we're getting kind of a little mired down is this extra contractual claims, because I think the law is well established that if it's going to create manifest injustice on the part of the defendant, then you necessarily have to sever those extra contractual claims. Now, that's not what we're doing here. This has been pled as bad faith, and then also under sections 541 of the Texas Insurance Code and the DTPA, and primarily as a declaratory action. And that was the same procedural mechanism by which it is under a deck action is to determine the plaintiff's rights and obligations underneath the insurance contract itself. Now, previously, and if the court would consider this, I've had, it hasn't been, we abated a number of issues to where we can move forward with compelling a deposition of the adjuster, correct? Because the adjuster has been sued in this case. We have sued both Allstate and the adjuster individually. So where you can gauge those things in order to have a court of competent jurisdiction determine under a declaratory action, which has been pled as a cause of action in this case, what the plaintiff's rights and obligations are underneath that contract. And meaning we can limit the topics that are covered in the adjuster's deposition to be narrowly tailored as to your evaluation of this claim. And I know we've gone over this is what I went over with Judge Mulberg, so that we're not getting into.
So how did Judge Mulberg rule on this?
The way that Judge Mulberg ruled on it was that he permitted me to take the deposition of the adjuster. He abated dealing with those kind of extra contractual claims, but allowed me to move forward solely limited under the declaratory judgment action that had been pled to get into not those things that would be manifestly unjust, right? As pursuant to that In re Progressive case, which would be settlement offers or a lack of settlement offer, not just more the evaluation of this.
Ms. Jobin, I mean, obviously Judge Mulberg, now Justice Mulberg, is very well-respected jurist in this county. in district, I guess, whatever, Court of Appeals district. And why shouldn't I just do exactly what Judge Mulberg did, or Justice Mulberg did? You know?
Because he didn't do that. I mean, the cases, I think she's a little confused. In this case, the declaratory judgment that they're seeking is they've alleged that they settling, that the un or underinsured motorist was negligent, and they wanted a declaratory judgment. This is that. The cases are consistent in that what they can do is that, number one, there should be severance and abatement of the extra contractual issues. It sounds like she kind of agrees to that, but I'm not certain I'm understanding her argument about whether or not she can ask questions about the settlement offers and how they got there. It's my understanding that the most progressive of decisions is that you can take the deposition of the adjuster as far as what independent facts they know about liability, and what their defenses are on these independent things, as long as they don't spill over into their evaluation. And I think Ms. Chandler is here to talk a little bit more about that as well. But Jackie, isn't that, I mean, that's my understanding of what all the cases are. Every case that's out there says you sever and abate.
Yeah. I mean,
as long as there's a declaratory judgment action play. In Canada, the tribunal, there's one case out there, actually two, that dealt with severance and abatement if there was no declaratory judgment action pled, and that's pending before the Supreme Court. We don't have that here. We have a declaratory judgment action.
Do you have a copy of the order from Judge Mulberg in his case?
That's what I was going to say, Judge. What I can tell, it was several years ago, but I can pull the cause number and I can pull the order that he signed, and he ruled on the list of topics that I provided in the motion to compel the adjuster. I believe Mr. Lohr has utilized the same thing. And just to be clear, I respectfully, Mr. Sewell, I'm not misunderstanding what happened in my own case. I took the deposition of the adjuster. So what had happened is that I had argued, look, it's, inherently against public policy. I think we should be allowed to ask about their evaluation of this claim, not getting into anything proprietary, right? But just going forward under the DEC action itself and what we're entitled to in that way. So I would be happy to provide the court with a copy of that order, and I think the pleadings that were filed in that case, I'm sure I can pull it off of Dallas County just online. It won't take me. I remember that case very well, because I will say that it was against Allstate. It was a different firm. I think it was Stacy Conder that was handling it, and it did encourage settlement. So I thought it was.
And it covers all the same issues we have here as well, including the motion to compel issues.
That's my understanding. As long as I'm clear, Mr. Stillwell, is it not accurate that Mr. Lohr has compelled the adjuster's deposition in this case?
Right. I mean, and before we move on, it sounds like, if I could ask a couple of questions, it sounds like whatever case you had was several years ago. Is that right?
And there's two Dallas Court of Appeals cases since then.
Yeah, the two Dallas Court of Appeals decisions that came in late 2018. And there's been case after case after case. And it sounds like, and so we don't get bogged down too much, Ms. Jobin, are you agreeing to the—
I'm not agreeing right now, John, respectfully, Mr. Sewell. Anytime that we've had these conversations about agreeing to something, we've had this mixing of words, and
well, then, okay, then
I'm not lead counsel on this. I'm simply, Mr. Lohr has had something come up. So
what I'm inclined to do, just because, it's hard to predict, because we have basically an entirely new Court of Appeals. Since 2018, we now have 11, I think, of the 13 justices are new, but Justice Mulberg is there. I would be inclined to kind of follow whatever Justice Mulberg did when he was on the trial bench. If it's the same, I don't know that it was the same, but if it was the same.
There's two Dallas Court of Appeals cases, though, that are exactly on point, that say you don't get into the extra contractual claims handling issues, and specifically under the claims that are pled into the insurance code, as are pled here.
And those are since 2000, since the new court took over.
No,
I
they're-
don't
they
know,
were
but
in-
the new court is bound to follow its own precedent. I mean, we don't take over and get a new precedent just because there are new justices. I mean, I think that the Dallas Court of Appeals opinions are
Precedent.
still binding on this court, and there's nothing that's to indicate that those cases wouldn't be binding. Plus,
However-
we don't even know what this order supposedly is. I mean, it's not even before us.
It up, right, I'm pulling it up.
And
Right,
Judge, I did cite a number of 2020 opinions from, last year, including like even the San Antonio Court of Appeals decision and the NRA Progressive, and where that court, I mean, the main thing I'm thinking of is looking at in the light most favorable to Ms. Jobin, which I don't think we have to do, but severance and abatement is proper. And then, so I would ask, it sounds like there's not an opposition to the severance and abatement. It sounds like the opposition is the scope of the deposition, which I thought that was really the crux of what we're going to be dealing with, in addition to the severance and abatement. The severance and abatement, I think, is absolutely proper.
I guess my question, and it, what I agree with you, Ms. Chandler, you're right, but the precedent would even if the Dallas Court of Appeals overturns their previous precedents, what I've seen them do a number of times, that it's not my job to do that. And so to the extent that there's been Court of Appeals decisions that are contrary to what Judge Mohlberg ruled on in this other order, I agree with you that I would have to follow the Dallas Court of Appeals opinions. But if the Dallas Court of Appeals is silent as to these issues, then I would go with the Justice Mohlberg's decision in this case. But Ms. Jobin, have you been able to find this opinion?
this case was from, we may need to call, I know there was a record of it. It's from.
There's no orders.
Give me the cause number, I'll look it up.
I don't see, I know he's up because the certificate of the adjuster's depot is in here, so I know he granted my
Well,
motion.
give me, with the certificate, they'd have the cause number. If you got the cause number, I'll look it up right now.
I'm telling, please let me finish. I'm telling you that the orders are not uploaded on here, but then there's the deposition I took is beneath it. Does that make sense? So I wouldn't have been allowed to depose the adjuster otherwise. So I'm telling you, I think that maybe the orders weren't uploaded.
Well, but we
Looking
had
at,
the cause number from the certificate would include the cause number. And if we could just have the cause number, then I can open up I've got the Dallas County Court.
I'm telling you that the orders are not on there, John. That's what I'm explaining to you, but I can see the deposition certificate of me taking the adjuster's deposition.
Okay,
I'm
may I
wondering-
have the cause number and I'll look.
Okay.
Or at least be a proposed order.
I know what you're saying. You're saying the order's not on there, but you can't expect for us to go along with something that we don't even have a copy of the order.
I can ask for the court because I can ask for the court to provide us with a copy of this. I'm sure we can contact and get a copy of it.
Could I have the cause number? I'll look it up right this minute.
It's 16, it's going to be the same thing, John, 1609554. And I can represent that I would never make a representation in front of this court. I think Judge Hoffman, I've been practicing in front of you for roughly 9 years if this was not an accurate statement. So
Okay, so is it DC 16, DC -16 -09554?
yes.
Okay, so that is, so it sounds like, are you opposing the motion to sever and abate? That's the number one.
I'm opposing the motion to sever and abate, and I think what I think would be for the limited purpose of determining just confined to a declaratory action to allow the deposition of the adjuster to go forward to determine the rights and obligations of the plaintiff under the insurance policy that was purchased. And what I'm not sure about is why we constantly hit these roadblocks where y'all don't want to produce your adjuster. I mean, I understand, I think that's kind of the whole public policy argument that I previously made in front of Justice Mohlberg is, you know, I purchase a policy from you that's $30,000 UIM. I now have to hire a lawyer who's going to take 40% of that $30,000 for me to, you know, so I'm actually not getting the full value of something I've actually purchased. So I think that we're entitled under a deck action to have my rights and obligations determined underneath that policy.
The whole issue about the deck action is pending at the Supreme Court right now. I mean, we just had oral arguments on it, and I know that for certain because it's my case. So right now, we don't even know if the Texas Supreme Court is going to say that you can assert a deck claim or a deck suit. So, you know, I understand you sound frustrated about, you know, insurance company in general's position, but that's a question that's open in Texas right now. So.
Judge, is there a way that I can share the order? Because I pulled up the order and it sustains the severance and abatement. And I
Okay,
believe
go ahead and share that, I guess.
Okay, I believe I'm just reading it quickly. Let's share it with you. Here's the order. And she's correct. It did involve Stacy and Condor. It says
No, he didn't. Right. He denied and let us take this. It's the same situation as here and allowed us to take the adjuster's deposition.
Says right here at the bottom, it says, and this is what it says, the alleged breach of the duty of good faith and fair dealing, breach of insurance, unfair insurance practices and so forth are hereby abated until the further order of the court is that it says all into it. The request for severance of all extra contractual claims into a new cause of action is denied, which most time they just leave it in the same cause, but they sever and abate it. It's all issues related to defendant's alleged breach of the duty of good faith and fair dealing, breach of fiduciary duty, unfair insurance practices, violations of the insurance code, violations of DPPA, and so forth, including discovery related thereto is abated pending the final judgment in cause number or further order of this court.
And Your Honor, he denied their special exceptions for the purpose to allow us to depose the adjuster, which is why this is applicable. I'm sorry if I misspoke. He denied their special exceptions as have been pled here, and allowing
pled any special exceptions.
Well, and
can you go back to the first page again of that so I can read it again?
Absolutely. We blow it up real big.
Yeah, the severance into new cause of action is denied.
We're not asking for a new cause of action.
Well, severance of all actions into a new is denied. So severance was denied.
But it was abated. The extra contractuals were abated.
That's what I'm trying to do here. The extra contractual claims were not denied. It was denied that you guys can't have those in separate cause of action. That was what I'm trying to explain. You're missing that second paragraph. I knew we're getting marred down the weeds. It is further order and judge all states' requests for severance of all extra contractual claims into a new cause of action is denied.
I don't ever ask for a new cause of action.
Okay.
I always ask for it all to be in the same case, and you pause, you abate that until there's a judgment, as it shows on page 2 of this order.
Right, Judge.
All I'm asking for is what the judge did.
Right, Judge Hoffman, the way that my understanding is identical to this situation, as Mr. Lord would like to move forward with the motion. I had a motion to compel the adjuster's depot, and it was at the same time as they were trying to sever and abate. Judge Molberg, as I recall, said, I've done and decided, look, I'm going to allow you to move forward and take this deposition. I'm not going to sever these extra contractual claims. We don't need to show legally entitled. We don't need to have one trial. That was what he said. And this order, I think we're kind of cherry picking, but this order is my understanding, and it was identical to this situation, so that the motion to compel the adjuster's deposition was granted, and I was allowed to go through with very limited topics. And I believe.
But I've never said that you can't get the deposition. In fact, I agreed about 14 or 15 topics. I've never said that you can't. I've never asked for a different cause number. I've asked to sever and abate the extra contractual claims,
Mr.
just like it's done in that other case and like it's done in every case.
No, Mr. Sewell, you just said, you started out this hearing saying we need to address my motion to sever abate, and then we'll be able to determine whether the second motion will be occurring. So I don't think that's entirely accurate.
If you saw the correspondence between Mr. Lohr and I, Judge Hoffman, after the last hearing, ordered us to sit down and talk about the topics. We narrowed it down to about 5 topics that we had at issue. And those issues have to do with the evaluations and how we got to the office, which, just like you said in that case, Judge Mulberg, I think I heard you say, said you couldn't go into that, but you could go into claims and defenses. And I kind of agree with that, because that's what the case law so far says. Although there is that Texas Supreme Court case involving USAA, and it's going up. I think they already argued it, but haven't decided it.
Yeah, there's
Okay, guys, so you guys have been fighting back and forth. I've just kind of been looking at some of the stuff from that case. So as to the motion to sever and abate, I'm going to basically just adopt Judge Mulberg's order that he did. So go ahead and just prepare an order that's as similar as possible to him on that point. As to the depositions, what's in dispute at this point? It sounds like Mr. Stillwell's not really opposing the taking of the deposition. The issue is the topics, and apparently that's been maybe narrowed down. What topics are we still fighting over?
I'm unaware. That would have to be something I would need to speak with Rob about. I know that the list of topics that I had narrowly tailored, I would assume he used the same ones, but I cannot speak with intelligence on that. I don't know what had gone on prior to this and what rulings you have made, Your Honor.
Okay.
We had agreed to like 15 of the 19 topics. And the issue was really just, what my only concern is, how far can they go as far as asking us about our position on damages. That's the main thing, because that goes into the evaluation of the case. And I think she'll even agree, it sounds like, that we can't go into the evaluation of the case, but I think you can go into, we agreed to a lot of topics like conditions proceeding, which we allege they failed to comply with. The policy, is there a coverage issue? Was it enforced in effect? Were the premiums paid? All those sort of things. What are the applicable limits? What are the offsets? What's the basis of those offsets? What types of benefits does the policy cover? PIP, MedPay, uninsured motorist benefits. Our position on the status of the insured, status of the other party, whether they had other insurance, and if so, how much. The identity of that driver, we agreed to all that. The dates and amounts of payments made on the claims, we agreed to all that. Any conditions of proceeding that Allstate believes the plaintiff may have failed to comply with. The only things that we really left up are just that are in dispute from my vantage point would be our position on liability and our position on damages.
Your Honor, well, briefly, if I can just explain, my understanding was that we previously, if we're adopting the ruling, I'm assuming it would be similarly situated, is I wasn't permitted to get into how they came to any evaluations that they did, right? You know, how some insurance companies use Colossus or whatever that may be. I wasn't allowed to get into that stuff, but in resolving any ambiguity in the contract itself, pursuant to a deck action, things like where it says is legally entitled to or will become legal. So language within the contract itself that was sold to the plaintiff was a primary topic of the deposition. So given pursuant to the deck action itself. So I think those are topics that'll be gone into, and the handling of this. Were you aware that this was sent to you on this day? You know, any correspondence limited to the confines of this particular plaintiff, not going into what rubric did you utilize in coming to this evaluation. Okay. My understanding, there are no offers made at all on this case. So I don't think that will become an issue.
Well, that's claims handling.
Right, but it would just be there, and that the policy does allow for mental anguish, that does allow for those different damage categories, I believe. And I don't want to speak for Mr. Lore, but I do know that those were topics that we were permitted to get in.
Ms. Jobin, I mean, you are here for Mr. Lore, so you need to speak for Mr. Lore. That's what the hearing is.
Speaking for him, those are topics that will need to be discovered, that will need to be covered in the deposition, but it's in the policy itself that was written by Allstate, right? So just the damage categories that it allows for, and that adjuster's understanding of what.
So why don't we just do this? Why don't you guys each submit orders if you can't agree to an order on this case as to it sounds like there's an agreement as to almost all the topics. We'll do a red line, blue line order. So Mr. Stillwell, if there's something that you want in the order that Ms. Jobin won't agree to, you put it in red. If there's something that Ms. Jobin that you want in the order that he doesn't want, you put it in blue. And then for everything you agree on, you put it in black. Same with the motion to sever and abate. I'm going to just adopt basically Judge Mulberg's order on that. If there's some difference of opinion on that, then not as to whether or not you agree with Judge Mulberg, but whether or not you agree that's actually the correct form of the order, then submit that as a red line, blue line as well.
His order is really similar to what I usually.
Yeah, I think it's fine.
Judge, I don't have a problem with that, but I think that's a great idea. Ms. Jobin, would you be willing to talk to Ms. Chandler and I offline for a few minutes, and we can?
I cannot do that actually right now. I've got to take my mom to get her second COVID shot. So
okay.
Otherwise,
Lucky her.
Good wishes on that.
At Parkland, so she's told me it's the second one. So
you don't want to be late. So, all right, well, great. Well, you guys try to work it out and just get me an order as soon as you can. Okay.
Thank you.
Hey, Jackie, can I call you offline? Would that be okay?
Yes.
May we be excused, Judge?
You may. Good
All
luck.
right, Judge.
Good to see you guys.
Thank you.
Okay, Tony, Nancy, we'll see you. I don't know where Nancy is, but Tony, we'll see you tomorrow at 9. Tony, you there? We'll see you tomorrow at 9.
I was asking, do we have a lot of trials scheduled?
We did it last time I checked. Let me see.
We're still on YouTube, by the way.
Oh, oops, sorry.